Hello and welcome back to the channel. In this video series, I am explaining how to get a declaration of nullity in the Catholic Church. In the previous videos, we have learned which marriages are invalid. Once we are sure about which ground of nullity best fits our case, we must bring the case before the tribunal and prove during the trial that the marriage was invalid. The canonical process is a masterpiece of the legal sciences. Having assimilated many elements of the Roman process, the canonical process is the impressive fruit of centuries of historical evolution. Therefore, it is not possible to explain it all in a small video. Moreover, even though the tribunals of the Church are subject to the same canon law, this law allows some freedom in the way to treat many practical issues. For these reasons, what I am about to offer is nothing else than a general description of the process. In the second video of this series, I explained the difference between dissolution and declaration of nullity, and in which cases it is possible to get a dissolution. In that video, I give as well a brief explanation of how the dissolution processes work. In cases of matrimonial nullity, three processes can be used: documentary process, briefer process, and ordinary process. The documentary process is the fastest and easiest of all. It can be used when it is possible to prove with documents that the marriage was invalid. This is why this process is so fast, because the nullity is proven by documents which are not subject to contradiction or exception. However, this process cannot be used in cases of defect of consent, but only for cases of nullity due to impediments and defect of canonical form. The briefer process before the bishop, on the other hand, can be employed in cases of defect of consent. However, it is necessary that both parties request the declaration of nullity, or at least that one of them requests it with the consent of the other party. Moreover, the briefer process can only be employed in cases in which the circumstances do not require a more careful instruction because the nullity is manifest. Most times, however, it is impossible to use these faster processes, and justice requires a more thorough assessment of the case. In fact, both the briefer and the documentary processes are abridged versions of the ordinary process. Since this is the paradigmatic and most common version of the process, we are going to take a look at the ordinary process, or to be more precise, the contentious ordinary trial of declaration of matrimonial nullity. The process starts when a spouse submits a petition to the tribunal requesting the declaration of nullity of the marriage. The spouse who submits the petition is the petitioner, and the other one is the respondent. The petition must indicate the ground or grounds of nullity that are proposed as the reason of the nullity. Moreover, it must give a short explanation of the facts upon which the petition is based, and a list of the proofs that will demonstrate during the trial that the facts are true. Most times, these proofs are the depositions of witnesses whose names are given in the petition. The petition must be submitted to the competent tribunal, which is the tribunal of the territory in which the petitioner lives, in which the respondent lives, in which the wedding was celebrated, or in which the majority of the witnesses live. Most church tribunals have lawyers and procurators who guide and represent the parties during the trial. In many cases, these professionals will be the ones who will prepare and submit the petition. However, in some places of the world this is not so. For instance, in many dioceses of the United States of America, the petition is prepared with a form. This form is filled in directly by the petitioners with the help of their pastor. Once the petition is accepted, the tribunal contacts the respondent to give notice of the petition's submission. The respondent's right to take part in the trial is a fundamental one. If the respondent refuses to cooperate, the trial can go on, but justice requires that they are given the right to intervene. Sometimes it is impossible to find a respondent. In these cases, there must be proof that the whereabouts of the respondent is unknown and that everything has been tried to find where they are. Once both parties and the defender of the bond have been heard, the judicial vicar, who is the head of the tribunal, issues the decree of the formulation of the doubt. This decree officially sets the precise question that the trial must answer. The object of this question is always whether there is proof of the marriage's nullity. Validity and nullity are not in equal footing with each other in the process. If the wedding was held, its validity is presumed. In other words, it is not the validity but the nullity of the marriage that must be proven. Next, the case is assigned to a court of judges and the instruction of the case begins. During the instruction, the instructing judge gathers the proofs of the case. In matrimonial cases, these proofs are usually the testimonies of the parties and their witnesses. However, there are other kinds of proofs, like for instance the psychological evaluation. The expert report, in which a psychologist gives his opinion about the mental condition of the subject, is very important in incapacity cases. There are also documents, private or public, which can be submitted as proofs. For instance, sometimes love letters or pictures are submitted to prove that there was an infidelity. Once the instruction is finished, that is, once all the proofs have been gathered, the judge decrees the publication of the acts, allowing the parties to read the acts of the case at the tribunal. Both the petitioner and the respondent have the right to read everything that has been declared during the trial and to examine all the proofs that have been presented. Once both parties have reviewed the acts, they can request the judge to obtain more proofs. If more proofs are gathered, they will have to be published as well. Finally, once the case is sufficiently instructed, the judge decrees the conclusion of the case. In this moment of the trial, the lawyers of the parties submit their briefs, that is, their arguments in favor of their client's case. Afterwards, the defender of the bond submits his animadversions. The defender of the bond is a person that must participate in all matrimonial cases, always defending the validity of the marriage. The animadversions are a report with all the arguments in favor of the validity of the marriage. When all the parties have submitted and exchanged their arguments, the judges meet to decide the case. Usually, matrimonial cases are heard by a panel of 3 judges. However, in dioceses without sufficient staff, the bishop can create a tribunal with a single judge as an exceptional measure until the situation gets better. The judges meet and exchange their arguments in favor or against the nullity. Ideally, they would be all in agreement, but if they are not, the majority wins. In order to give their vow in favor of the nullity, a judge must reach moral certainty that the marriage is invalid. This certainty is not an absolute one, which precludes even the mere possibility of the opposite. It is a certainty which precludes any reasonable doubt that the marriage may have been valid. Once the verdict is reached, one of the judges drafts the definitive sentence. The sentence is immediately notified to the parties. The trial is over, but this may not be the end of the road. Both parties and the defender of the bond have the right to appeal. If there is an appeal, a new trial will begin in second instance before the appeal court. If there is no appeal, the affirmative sentence becomes executive, which means that it is possible to act according to the verdict of the sentence. In other words, if this marriage that has been declared invalid was the only impediment to celebrate a new wedding, it is now possible to do it. Thanks for watching. I hope that this video series about the matrimonial nullity has been helpful for you. If you like these videos, please share them with those who may find them useful. If you have questions, write them below in the comment section and I will be happy to help.